whether second respondent, who by first respondent's own showing did not poll up to 25 of the total votes of the Federal Capital Territory, was properly returned by first respondent having regards to the provisions of Section 134P of the 1999 Constitution of the Federal Republic of Nigeria and other relevant statutes. It is therefore in order. I am afraid paragraph 114 of the petition 115 and 116, and paragraph 4, where they said purported results from 6,418 polling units have and indicate zero accreditation, and paragraph 118, where they avert that critically, paragraph 118 and 119 are all bad for lack of particulars of necessary facts. As for the statistician's report, again referenced by them for the said particulars, I hereby reconfirm my earlier finding and conclusion on it. Paragraph 120 of the petition is not challenged by first respondent, so I shall overlook it, at least for now. The petitioners in paragraph 121 of the petition allege that first respondents, presiding officers of polling units, failed to properly fill and countersign alterations in election forms, including forms EC, 8B, and blah, 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 but they did not mention the polling units. What local government and state said infractions took place. They simply reference the same statistician's report. This paragraph is bad for imprecision and so also liable to be struck out. Paragraph 122 to 125 of the petition are not challenged by respondents, so I shall skip them. In paragraph 126 of the petition, the petitioners complained that all over Nigeria, there were manifest cases of overvoting. The total of the affected polling units in the various states are set out in the statistician's report, pleaded and relied upon by the petitioners. This pleading is also, end quote, sorry. This pleading is also bad for vagueness. My earlier position on the statistician's report referenced by the petitioners is also reaffirmed. Paragraph 127 and 128 of the petition are not challenged by first respondents, so they are also skipped. I do not share the view of first respondent that paragraphs 129, 130, that's INEC, that paragraphs 129, 130, 131, and 132 of the petition are bad for lack of imprecision. Petitioners in those paragraphs carefully pleaded the specific polling units and numbers of votes therein that they claim were affected by the cancellation of elections complained by them. I am, however, of the opinion that the second complaint of first respondent against paragraph 129 of the petition, that is also deserved to be struck out for petitioner's failure to join Honorable Adejo, chairman of Oloma Boro local government of Kogi State, accused by them of having led thugs at gunpoint to force electoral officers in named polling units in Oloma Boro local government to declare concluded elections in the said units cancelled, is well made. The petitioner's response that not only was no relief claimed by them against Honorable Adejo, he did not even participate, quote unquote, in the election, neither was he returned, so it's not a petition contemplated by Section 133 of the Electoral Act to be joined to an election petition. It's not a valid response. Section 133 of the Electoral Act only deals with the issue of which contestant of an election ought to be joined in an election petition by a co-contestant. It has nothing to do with the issue of joining of third parties against whom allegations of electoral infraction are made by practitioners, as in this case. Such petitions must be joined to the petition if the court is not to be exposed to the risk of infringing their fundamental right to fair hearing guaranteed by the Constitution. It is also of no moment that no relief was claimed against such persons in the petition. What is important is that allegations of electoral malpractice, which will require the court to make findings, including condemnation of the alleged conduct, where necessary, are made in the petition. Support for that position can be found in Wankwo and Yaradua, where Muntaka Kumasi JSC, after reproducing the provisions of the then newly enacted Section 1441, sub 2 of the Electoral Act, which is now Section 1332 of the Electoral Act 2022, and confirming that that provision had done away with the old regime of the Electoral Act that required petitioners to join all relevant electoral officers of INEC that conducted an impugned election. In addition to INEC, said, this is what his lordship said, unless the conduct of a petitioner who is not an agent, or the conduct of a party who is not an agent of the commission is an issue, it will then be necessary to join such party as a necessary party to the petition in order to afford such party a fair hearing, end quote. As regards the consequence of failure to join such necessary parties on the petition itself, his lordship Kumasi again said as follows. However, where such a party is not made a party, it will not result into the old petition being struck out. And the particular allegation against such party is liable to be struck out, end quote. That is the fate of paragraph 129 of the petition, where allegations of electoral malpractice were made by the petitioners against Honorable Adejo, yet he was not cited in the petition. Incidentally, this is also one of the main reasons the Supreme Court gave in dismissing the appeal of the petitioners, In the Odo State governorship case of Eitai Ojegede and another versus INEC, where allegations were made by the petitioners in that case against the then National Caretaker Committee chairman of the present head respondent APC, Governor Mai Malabuni of Yobe State, yet he was not joined to the petition by the petitioners. Paragraph 129 of the petition must therefore suffer striking out. For the same reason, paragraph 133 of the petition, where similar allegations of an alleged gun-toting Governor Yahaya Bello of Kogi State leading talks to compel cancellation of concluded elections in polling stations were made, yet he was not joined to the petition, must also be struck out. Paragraph 135 and 136 of the petition were not challenged by first respondents, so they are hereby skipped. I consider this a convenient point to consider paragraphs 137 and 142 of the petition, which learned senior counsel to INEC further complained was also barred for non-joinder. Counsel's argument this time was that the petitioners were also seeking in those two paragraphs to avoid the entire results of the presidential election in Lagos and Kano states, as declared by INEC, where Mr. Peter Obi of the Labour Party and Rabiu Musa Kwankwaso of the New Nigeria People's Party scored the majority of lawful votes. Yet Peter Obi of the Labour Party and Rabiu Musa Kwankwaso were not joined to the petition, so those paragraphs were also barred and liable to be struck out. I consider this argument misconceived. In fact, it seems to overlook Section 134, sub 4 of the 1999 Constitution, stating expressly that, and I quote, "For the purposes of an election to the office of President, the whole of the Federation shall be regarded as one constituency," end quote. That is the position as it relates to a presidential election. Percentages of votes polled by presidential candidates in any of the 36 states of the Federation or even the Federal Capital Territory only become of consequence when the issue verges on whether the candidate returned also satisfied the provisions of Section 131B and 2 of the 1999 Constitution, as amended, requiring him to poll 25% of votes cast in at least two-thirds of the 36 states and the Federal Capital Territory. Outside of that, how many votes a presidential candidate polled in any of the states of the country is of little significance in an election petition challenging return in a multi-party presidential election. It certainly has no bearing on the question of who an aggrieved party challenging a presidential election return should join to his petition among the candidates that contested the election with him. By Section 133 of the Electoral Act, the only other candidate in the election the petitioner can properly join to his petition, the person returned as the winner of the election. See further on this, the cases of Buhari and another versus Yusuf versus Obasanjo and 50 others, Obasanjo and Yusuf versus others, see particularly Buhari and another versus Yusuf, where it was said by, and I quote, by the Supreme Court, where it was said that, and I quote, "An unsuccessful candidate in an election cannot be made a party to an election petition against his will," end quote. We also do not agree with first respondent that paragraphs 141, 41, and 142 of the petition were vague or imprecise. But I do not, sorry. I am rather of the view that facts necessary to elicit an appropriate response from the respondents of the electoral infractions complained of by the petitioners have been pleaded in those paragraphs. I, however, agree with first respondent that paragraph 142 of the petition, where the petitioner simply complained that first respondent deliberately entered wrong results. For 22 named states therein, paragraph 44, where they averred that there were discrepancies on very large scale at the various local governments, various levels of recording and collation of results, particularly between the polling units and the ward polling centers, without specifying the said polling units and ward collation centers, where these said, quote and unquote, large-scale discrepancies took place. And paragraph 144, where petitioners gave notice that they would rely on their same flawed statisticians' report, among other documents they did not front-load, are bad and liable to be struck out for vagueness. Paragraph 142 of the petition, where petitioners simply stated as ground 4 of their petition that the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, quote and unquote, that is all they said, is also imprecise and vague as it gives no particulars of any of the several qualifying and disqualifying factors set out in sections 131 and 137 of the Constitution. The main purpose of pleadings, as further fortified by paragraph 4 sub 1b of the first schedule of the Electoral Act, we repeat, is to properly and clearly inform the adverse party of the case is coming to meet, so that he can respond appropriately to it. That is fair hearing. That requirement of the law does not permit parties to keep their cards face down, as petitioners did in paragraph 146 of their petition, when they simply aver generally that second respondent was not qualified to contest the 25th February presidential election, without revealing in what form he was not qualified or disqualified for the election. That paragraph of the petition falls far short of the requirements of paragraph 41B of the First Schedule of the Electoral Act and so liable to be and must be struck out. Conclusion on issue 1 of first respondent, the sum total of all the foregoing is that while paragraphs 129 and 133 of the petition are liable to be struck out for non-joinder, to which Mrs. Adejo and Governor Yahaya Bello of Kogi State accused the petition of committing electoral malpractices, paragraphs 92, 95, 98, 11, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack particulars, and so fall short of the requirements of paragraph 41B. They are all therefore ordered struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 100, 111, 112, 113, 114, 115, 16, 118, 19, 120, 122, 125, 130, 134, 138, 139, 140, on the other hand, are in order and properly pleaded. Now, issue 2 of first respondent in this same application reads whether having regard to the mandatory provisions of paragraph 41B of the First Schedule of the Electoral Act, a reasonable course of action has been disclosed in respect of grounds of the petition contained in paragraph 16A, B, C, and D of the petition to warrant further or any adjudication on same. Counsel on behalf of first respondent this time anchored the arguments principally on the grounds on which petitioners founded their petition. Counsel reproduced paragraph 16A, B, and C of the petition where the petitioners alleged, we set them out. The next reference, section 134 of the Electoral Act, stating that an election may be questioned on, among others, that the election was invalid by reason of corrupt practices, and argue that this provision, that is section 134, has a proviso in section 135(1). So the fact that an election shall not be liable to be invalidated by reason of non-compliance with the provisions of the Act, if it appears in the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and the non-compliance would have substantially affected the result of the election. Relying on the cases of Ojukwu and Yaradua and Yusuf as a judge, Learned Counsel submitted that for petitioners to sustain their ground of corrupt practice and non-compliance of the election with the provisions of the Act, they are required to not only plead the fact of non-compliance, but further assert positively in the petition and prove that the non-compliance and corrupt practice complained of substantially affected the result of the election. To properly do that, they argued petitioners must plead and show how many votes were affected by the irregularities and that the deduction of such votes would void the return of second respondent as the winner of the election. He said not only did the petitioners not assert in their petition that the non-compliance complained of substantially affected the election, they did not also plead the votes or polling units affected by non-compliance to enable this court to form an opinion on that non-compliance and corrupt practice complained of substantially affected the result, or that second respondent polled majority of lawful votes in the election and so ought to be returned. Without those facts in the petition the petitioner's counsel submitted, have simply blown quote-unquote muted trumpet and their petition lifeless and failed to disclose a substantial cause of action, so it is liable to be dismissed. Resolution of issue 2. This issue does not, in my view, deserve any serious consideration. The reason being that petitioners expressly stated in paragraph 17 of their petition that, quote, the petitioners are aware that the election was not conducted in accordance with the provisions of the Electoral Act and other relevant laws, and that the non-compliance substantially affected the result of the election. In that, the second respondent ought not to have been declared and returned as the winner of the election. That sufficiently answers the question of first respondent. Issues 2 and 3 and 4, the first respondent first application. Answer to first respondent, their issues 3 and 4, which they also argue together, basically relied on their contentions in issue 2 of the lifelessness of the petition to submit that the petition, as by reason of the alleged submission in the petition identified above, had become academic and constitute abuse of process of court, so this court is robbed of jurisdiction. Entertain it. This combined issue is founded on issue 2, and since issue 2 has been determined against first respondent, issue 3 and 4 perish with it, and so are hereby resolved against first respondent. Now I come to second respondent similar application, seeking dismissal of paragraphs 14 and 15, 19 to 81. For this application, Learned Counsel second respondent simply said that the sole issue for determination thus was that in view of the provision of paragraphs 14(1)(d) of the first schedule to the relevant Electoral Act and relevant judicial decisions, whether paragraphs 14 and 15, 19 to 81, 87 to 104, and 108 of the petition are not liable to be struck out. We set out the arguments, both of them. He said, in the course of determining first respondent's application on the same issue of vagueness and precision in the complaints, I dwelt extensively on the rationale for exchange of pleadings, generally and particularly in election particulars, as further set out by the lawmaker. I hereby adopt all those pronouncements. Same exercise are also considered and pronounced on the same complaints of vagueness, lack of particulars, generic and imprecision. Of the complaints of the petition, paragraphs 92 to 146 of the petition, also made by the second respondent here, I there determined, we said what we listened, and we said, I abide by those findings. I shall therefore simply focus on paragraphs 14 to 19 and 147 to 150, and the few paragraphs between paragraphs 92 to 146 of the petition omitted by the first respondent in the application determines the complaints of second respondent of whether petitioner's complaints in those paragraphs were vague, imprecise, and generic. I now start that exercise without reference to what I had said earlier, and which I hereby reconfirm on the invalidity of the statistician's report relied on by the petitioners for particulars of the averments in the petition. I am of the opinion that paragraphs 14 to 15 of the petition, where the petitioners specifically complained only about correctness of the contents of INEC forms, are so clear as to the issue raised and so not vague. Paragraph 16 of the petition are not attacked by first respondent and so are also skipped. We also do not find paragraph 20 to 20 of the petition where the vague. We do not also find paragraphs 20 to 20 of the petition where the petitioners complained that first respondent did not keep to his earlier promise of electronic transmission of election results to its IRF portal in real time when it returned this thing vague. We, however, find vague, imprecise, and falling far short of the requirements. I, however, find vague, imprecise, and falling far short of the requirements of paragraphs 4(1)d and 15 of the first schedule of the Electoral Act 2022, the averments in paragraph 22 of the petition, where the petitioners complain that the result of the election as announced by INEC does not represent lawful votes, and that lawful votes cast for them were massively deducted from their scores. Those paragraphs ought to contain the lawful votes of the petitioners that were alleged, quote, massively deducted, as well as those alleged to have been allocated to second respondent by INEC. We find properly and sufficiently pleaded paragraphs 24 down to 72 of the petition. We, however, find vague, imprecise, and lacking particulars paragraphs 82 to 86 of the petition, where the complainants complain that permanent voters' cards collected the unit results where elections were collected or did not hold across the country is above 1,000, is above 1,810,206, which is the margin of lead between first petitioner and second respondent. Consequently, the turn of second respondent was hasty, premature, and wrongful. This pleading ought to contain the precise number of permanent voters' cards alleged collected in the polling units, which by petitioner's contention would have closed the margin of lead between first petitioner and second respondent to make the latter's return unlawful. Without that information, the complaint is difficult to understand and respond properly to, let alone resolve. Paragraphs 87 to 90, where the petitioners complain of corrupt practices in the conduct of the election, which practices they complained took the form, among others, of manipulation by second respondent through deliberate suppression and discounting of votes, is vague insofar as the polling units where the said corrupt practices took place are not stated. Paragraphs 92 to 97 of the petition, less paragraphs 135 and 36, also complained of by second respondent as vague, imprecise, and generic, have been dealt with by us while considering first respondent's petition on the same issue. We hereby adopt our findings in that application, resolving the complaints of second respondent in this application. As for paragraphs 135 and 136 of the petition, we have the view that paragraph 135, where petitioners complain of manipulation of election in Lagos State by first respondent, resulting in depletion of their votes and inflation of second respondent's votes, is vague in the absence of pleading of the number of votes so depleted and inflated. In respect of paragraph 136 of the petition, even the petitioners again complained, that the votes returned by the first respondent for Obi Akpo and Port Harcourt local areas of Rivers State did not reflect the actual votes. If not express the SL votes, actual votes scored in the said local government areas, or even those updated to IRF by INEC and so liable to be voided, no correct quote and unquote figures of the actual votes cast as reflected in the IRF were pleaded. So it is also bad for vagueness and imprecision and therefore liable to be struck out. Sum total of the foregoing are complaints of vagueness, imprecision, and genericness of averments, all by second respondent against the petitioner, only made out as regards paragraphs 23, 82 to 86, 89 to 91, 92 to 95, 98, 121, 124, 126, 129, 133, 135, 136, 147, 144, and 146 of the petition. Accordingly, those paragraphs are hereby struck out, while the remaining paragraphs of the petition are deemed in order and pass the vagueness test of paragraph 4.1d of the first schedule of the Electoral Act. In pronouncing the said paragraphs of the petition bad for vagueness and liable to be struck out, we are not unmindful of the argument of petitioners that second respondent's remedy lies in an application for further particulars and not striking out. We are, however, of the petition that application for particulars is only one of several options open to second respondent, who in any case is not under any obligation to help petitioners make out their case against him by asking for particulars of their generic and nebulous complaints. That is also the point that was made by Fabi EJS in PDP versus INEC, when his lordship said at page 524 that, and I quote, the application for another for further particulars or the like is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, or devoid of necessary particulars. The decision in Olawekpo versus Saraki, cited by learned counsel on both sides, is in point. It is not the duty of a respondent to groom a petitioner on how to draft his petition, end quote. It is also quite revealing, if not even reassuring, we must say, that this argument of the petitioners of duty of second respondent to ask for further particulars, because that's their main argument, in their petition rather than asking for striking out the particulars, was also rejected by Muntaka JSC while delivering lead judgment in PDP versus INEC in 2012. Even as the same argument had found favor with his lordship, that is Muntaka, 2 years earlier in his contribution in Nwankwo versus Yaradua. His lordship in the latter case of PDP versus INEC endorsed the stand of trial tribunal in that case that paragraph 12, sub 5 of the first schedule to the Electoral Act, same as paragraph 12.5 of this present Electoral Act, permitting respondents to apply to strike out a petition did not exist in the 2000 Electoral Act in force at the time Nwankwo and Yaradua was decided, and that made all the difference. Regarding the further argument of second respondent, petitioners complained that first respondent did not observe his own promises to transmit election results to IRF portal in real time, was caught and made comatose by Section 134 of the Electoral Act, stating Electoral Act. We think it is, I think it is neater and even safer to defer it to the main argument for determination on its merits, especially since that contention is also one of the main complaints of the petitioners in the petition itself. That is what case law decides. Advice is sorry. See again Nwankwo and Yaradua, citation given. Third respondent's application on the same issue of vagueness of paragraphs. Our own application, that is the third respondent this time. In his own application of 8 May, third respondent, like the first and second respondents, also pleaded us to strike out all of paragraph 17 to 146 of the petition on the same grounds of vagueness, imprecision, blah, 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 and failure to join Mr. Adejo and Governor Yahaya Bello of Kogi State, against whom allegations of electoral infraction were made. Additionally, it's also complained that petitioners have amendments in paragraphs 19, stated them, and 45 of the petition are all pre-election matters which occurred after the petition and outside the jurisdiction of this court, sitting as an election petition. Again, the petitioners argued in response that their complaints were properly pleaded in the petition and so not imprecise, nor pre-election matters as alleged by third respondent. Resolution. Since the application of third respondents relates to the same paragraph of the petition objected to by first and third respondents, over which we have already made findings, we abide by and adopt those findings in determining the application of third respondent. We further hold that petitioners have amendments in paragraphs 19, 20, 21, 35, 41, 42, and 45 of the petition are not pre-election matters. In fact, whereas issues of the assurances given by INEC of real-time transmission of results to IRF raised by petitioners in paragraphs 19 and 20 of the petition, how the elections were generally funded by the federal government of Nigeria on account of those assurances as averred, and how first respondent transferred his in-house expert from one department to another before the election as alleged in paragraph 35 of the petition, cannot by any means give rise to a cause of action, let alone a reasonable cause of action. In petitioners, what is there? In petitioners, the amendments in paragraph 42, 43, and 45 of the petition are simply notices by the petitioners to subpoena witnesses, testify about first respondents' omissions and commissions in the conduct of election, and so cannot by any means be described as causes of election, let alone pre-election matters for which they could have commenced action as alleged. In conclusion, the applications of first, second, and third respondents succeed only partly, and the following orders are made on them. Paragraph 23, 82 to 89, 88 to 91, paragraph 95, 95, 98, 121, 124, 126, 129, 133, 135, 136, 143, 144, and 146 are hereby struck out as prayed. The remaining paragraphs of the petition attacks past the vagueness test and paragraph 41D of the first schedule of the Electoral Act 2022 and are hereby upheld. That leaves us with the standalone application of third respondent also filed on 8th of May 2023, as well as the three applications of third respondents, all objecting to the petitioner's replies to their petition. To their reply, sorry. Second respondent, so we take that one. We try to produce the arguments there. We said, then we went on to say that the thrust of the response of petitioner's counsel, that is 45543. Thrust of the petitioner's counsel is a suit number SCV-CV351 that was not filed by the petitioners. So this petition, sorry, okay, I'm still reading, 544. That now it is settled position of the law that once a court is satisfied that a proceeding before it amounts to abuse of process, it has the right and indeed duty to invoke its coercive powers to punish the party in abuse. Quite often that power is exercised by dismissal of the action that constitutes abuse of process. But multiplicity of actions, which is the complaint here, on the same subject matter and issue will only constitute abuse of judicial process if the parties in both actions are the same or previous to one another. See Okafor v. Attorney General of Anambra State. It necessarily has to be so because except where a person is shown to be privy of another as recognized by law, no man can be punished for the actions or sins of another. That is the crux of the issue here. It is whether the petitioner, that's Alhaji Atiku Abubakar, and his political party, the PDP, can be properly described as previous of the governments of Adamawa, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto states, who undisputedly instituted suit number SCCV against the Attorney General of the Federation before the Supreme Court of Nigeria. That question can only get a negative response. But the government of a state, regardless of the political party platform on which its executive governor is or was elected, represents all shades of opinion in the state, including even those who may not belong to any political party at all. In fact, a state government is not even bound nor obliged to take instructions from the political party of the governor. Interestingly, our law reports are replete with cases where state governments elected on the same party platform with the federal government have repeatedly sued the federal government at the Supreme Court. A good example is this. Okay. A good example is the recent new currency case. The new currency case that was instituted by the Attorneys General of Kogi, Kaduna, and Zamfara states against the federal government, even as both parties were APC governments. In that situation, one wonders where counsel would place this proposition of privity by affinity. There are other cases, we cited them, so we go on and on. In short, we reject this argument of second respondent of abuse of judicial process on account of litigation commenced by state governments against the Attorney General of the Federation. That is, as we also take note of the notice of discontinuance of case the said suit number SCCV 354/2023 filed by the plaintiffs in that case since the 3rd of March 2023, which notice was tendered by the petitioners in this court as Exhibit PV in the course of the hearing of the main petition on the 6th of June 2023. This court is obligated by Section 1221M of the Evidence Act to take judicial notice of its proceedings. The other argument of note of second respondent in this application is the one of failure of petitioners to again join Friday Adejo and Yahya and its effect on the petition. We have already struck out the relevant paragraphs of the petition where allegations of malpractice were made against the two gentlemen. We abide by that decision. Just simply add that we do not agree with second respondent's argument that the entire petition merits dismissal for non-joinder of those two men. Proper sanction in circumstances of this case, as we have already pointed out, citing Nwankwo and Yaradua, to strike out the paragraphs of the petition where those allegations were made. That order will also further add, and contrary to the argument of second respondent, will not affect the paragraphs where allegations were made against unnamed thugs. Unnamed persons cannot be joined to an election petition like it is sometimes done in trespass cases. Obasanjo and Yusuf, where a similar argument was rejected out of hand by Kutigi and Pastor Chalon on JSC. Thus, it was said there that it said, quote, it is impossible to drag unknown touts, police, and hordes of others to court and join them. That would be bizarre, end quote. So the next one, we now go to the challenges, the replies filed with the petitioners. All the respondents also challenge the validity of the replies and the accompanying witness statements on oath and list of documents petitioners served on them in response to their replies. Their common complaint in those petitions is that the said replies or paragraphs thereof offend paragraph 16 of the first schedule of the Electoral Act governing filing of replies by the petitioner and so liable to be struck out. First respondent's objection was against the reply of first petitioner that was served on it. They sought striking out of paragraphs 1.1, 21, 23, and 21 of the petitioner's reply, striking out the further witness statement on oath of DM, who later revealed himself in the production as Senator Dino Melaye, and PDPC, both deposed on 20th April, striking out the petitioner's list of additional documents dated 20th day of April, which accompanied it. Thrust of the argument, which is counsel founded principally, and we reproduced the argument, and we reproduced the reply. To start with, I am not persuaded by the petitioner's argument that the new facts or issues raised by them in their impugned reply relate to non-qualification, which is one of the arguments, and not the conduct of the election by first respondent. The second respondent, who is supposed to be first respondent, that is INEC, who is supposed to be neutral in that matter, cannot be urged to be objecting to them. The issue raised by first respondent, that is INEC, actually relates to the competence of a major process before the court to which the reply filed by petitioners. It is an issue which counsel to first respondent as ministers in the Temple of Justice, and even first respondent itself as a party to the petition, have a duty to bring to the attention of the court. That obligation even becomes more pronounced when it is realized that a substantial number of first respondents counsel are members of the inner bar who even have greater responsibilities to the court by virtue of their ranking. This preliminary objection, like the argument of petitioners, therefore rejected. Coming now to the merits of the application, it is common ground that the provisions of the Electoral Act most relevant to the resolution is paragraph 16 of the first schedule. We reproduce it. This provision, with the employment of the word shall, forbids the addition of new facts, especially if such new facts may have the effect of tending to amend or even just adding to the contents of this petition. Cited cases, and I think we have spoken on it in 03. Incidentally, this paragraph also reflects in the case of this thing, only restates the well-settled position of adjective law that a claimant's claim or grievance are made in a statement of claim or petition as the case may be, and not in his reply to the statement of claim to that claim, statement of defense to that claim. That position also finds expression in Olubodu and Lawal. He cited what the Supreme Court said there. They said a plaintiff must not in his reply make any allegation of fact or raise any ground of claim different from what is contained in the statement of claim. If a plaintiff does such a plea is irretrievably bad and no evidence would be admissible in his proof, end quote. In fact, that settled position of law is that except in some well-defined situations, a reply to a statement of defense is not even permitted where no counterclaim is served. This is so because there is in law an implied joinder of issues on any fact raised in the statement of defense, and any averment contained therein is deemed denied, as cited. And so what will amount to a new issue, we cite again Egesimba versus Nuzurike, earlier cited in appeal number 03. Guided by all these and paragraph 16(1)(a) of the first schedule, it does not by any means appear to me that the new facts of conviction, conviction/fine, forgery, and dual citizenship of second respondent introduced by petitioners into their reply. The additional averments of how results could not have been uploaded to INEC's IREV after the 25th of February, and C, whether it was done at all and relevant officials of INEC could not have been involved in it. Not to talk of the repetitions reply of averments already made by petitioners in their petition can pass as reply filed pursuant to paragraph 16(1)(a) of the Petition Electoral Act, particularly as relates to the further details as are quote and unquote, as petitioners labeled them in their reply, of non-qualification of second respondent contained in paragraph 2(1)(b) of their reply. It bears reiterating that all that the petitioners refer to in paragraph 146 of their petition is the bare statement that, quote, the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, unquote. No details whatsoever was given by them of what they meant by second respondent's non-qualification. So first respondent, who was obviously satisfied that second respondent was qualified to contest the election by the documents he presented to it, also simply joined issues with them in a similar general manner. It is now through their reply that petitioners, who themselves seemed to have had no clear idea of what they meant by second respondents' non-qualification for the election, or simply deliberately kept it back when filing their petition, want to now introduce through their reply at a time when respondents have no further right of responding to them. Such unfair tactics cannot and is not allowed by our law. It must be noted, too, that under Section 131 of the 1999 Constitution of this country, there are as many as 4 different qualifications the person must possess before he can contest presidential election, and another 10 different grounds that can qualify such a candidate who has all the 4 qualifications of Section 131. Therefore, an assertion that merely says that a person is not qualified to contest election by reason of non-qualification will leave not just the person so assailed, but every other person involved, including the court, at a loss as to what the pleader has in mind. In fact, to allow such pleading will amount to upsetting the very essence of filing pleadings in a case, which is to give the adversary and the court a clear notice of the pleader's case, a point further fortified in paragraph 61A of the first schedule to the Electoral Act. Still on this issue, I must not fail to point out that the petitioners were only being clever by half when they claimed in paragraph 21B of their reply that they were simply given, as they put it, further details, quote and unquote, of the non-qualification of second respondent by averring to the conviction, fine, certificate, forgery, and dual citizenship of second respondent that they raised in their replies. They had never given any details of second respondent's non-qualification, and so cannot talk about further details, quote and unquote, let alone hide under such further details to smuggle in the new facts they averred in paragraph 1B of their reply. These new allegations are not also mere, as they call it, evidence in support of their ground of his non-qualification, as their counsel also tried to make them out. They are facts which can only be contained in the petition itself, and not in the petitioner's reply to respondent's defense to the petition. Paragraphs 2(1)b and c of the reply, where petitioners aver to no uploading of polling unit results by first respondent, presiding officer at the election, we also agree with first respondent, are new issues or at least mere further denials by the petitioners, respondent denials of the petition. Such is not also permitted in the reply. See again, Bakar and another, versus Ibrahim, Akeredolu versus Akinremi, Egesimba versus Nuzurike, Spasco versus Alrain, Ishola versus LGB, and Obot versus CBN. In the light of all the foregoing, the 2 witness statements as well as list of documents accompanying that reply, all of which were based on the new facts contained in the impugned paragraphs of reply in issue, are also incompetent and liable to be struck out. In summary, first respondents' applications of 9th May succeeds in its entirety. Accordingly, paragraphs 1, 2, stated them of the 1, 2, Roman figure 1, Roman figure 2, Roman figure 3, Roman figure 4, Roman figure 5, and 2(1)b, 2.1b, c, and d of the petitioner's reply, filed a response to the reply of first respondent together with the 2 witness statements on note and list of documents which accompany that reply are all hereby struck out. Second respondent's application seeking striking out a